Welcome, everybody. This is part of an ongoing series where I'm trying to capitalize on the interest and attention that has come to this area of the law from the prosecution in London, Ontario of 5 hockey players that I'm sure everyone's aware of. I put out earlier, just not long ago at all, a couple of days ago, I put out a talk that I've been doing for the last year called Everybody Loses. And the purpose of that talk was to convince people that we need serious change in the way in which we conduct sexual assault trials. The focus of that particular presentation was on delay and the idea that delay is killing all of us. It is ruining things for defendants, complainants, prosecutors, and judges alike, as well as causing a lot of the general public to lose confidence in the system at large. I don't have all the answers for that, but in that presentation, I put out 5 solutions or proposed solutions that I think would help. In this new series, I'm trying to put out things that I think are win-win proposals that people can get behind and sort of work together to change the way in which our system works. I don't know if that's going to work here, but I can tell you that in this short presentation, I'm going to include my thoughts on the proposal, and then I'm going to include some comments from a range of lawyers, victims advocates, and law professors about how they feel about this particular proposal. So the basis of the proposal is based on my concern about 2 things: complexity and court time. Complexity makes everybody a loser, and I believe the procedural protections that we have in the best interests of complainants have been made into a way that's not actually helpful to complainant interest, and it's not really good for everybody. The procedural regime is causing a massive amount of complexity and incredible delay. We need to streamline that system, but I'm trying to do so in a way that does not take away any of the hard-earned protections that have been put in place for complainants. So I'm going to try to do that by looking at our system and figuring out if there's anything we can do better without necessarily taking away. In other words, instead of making everybody a loser, I'm going to try and come up with a proposal that makes everybody a winner. I've told you that I call these sections the beast that swallowed the world because they're voracious. They attack everything. The more you include in section 276 and 278.92, the more delay you create for the system. As you can remember, if you've watched my other video, I don't say that because I'm a defense lawyer who doesn't like those sections, though I admit I have real issues with them from a defense perspective. But what I've tried to explain is they're swallowing the world for everybody. The beast doesn't care who it swallows. So as a result, it's hurting all of us, and we need to change that. And the only way to do that is to reduce the scope of the sections. How do you do that? Well, you have to look at what Section 276 was designed to do, and I'm saying 276, but for the purposes of this presentation, it's both. They're the exact same. So remember that these were pretrial applications with a 2-stage process. One of my proposals in the other video was make it a 1-stage process, but I'm going to leave that for now. I had issues with the old one, but the big changes, these are the changes I went through in the other video. The major changes are these, right? It's a lot of paperwork. It covers an enormous amount of things. The inclusion of sexual communications has expanded it. The Crown is covered. The trial judge has oversight, and it all requires paperwork and a 3rd lawyer. So how do we reduce that without taking away? Because in my other presentation, I've suggested reducing the scope. Let me just say, getting rid of stage 1, I think those are all still very good ideas, but I'm not going to push them here because I've come up with something that I think is different. And the way to do that is by reversing 3 elements of the scheme that are created by the common law. They have nothing to do with the section, so I won't be removing any protections from anybody. You'll see. So, what would I do? I would go after the three things at the end that I think can be covered. The Crown evidence is covered too, is something that was created by the common law in Barton and Kinnemore. This was not something that the law requires. Fourth, trial judge retains oversight. There are no agreements permissible anymore, and I'll show you why that is. I think that's a mistake. I want to bring consent back to the system. But how do I do that in a way that does not weaken the protection that complainants have? Well, I have an idea. Really, we just need to think outside the box. My solution is to remove the court from the primary equation and give it back to the hands of the parties who actually need to make the decision. So you do that by doing this. You remove the Crown oversight regime. Just get rid of Kinnemore and Barton. You can do that by legislation, and I'm going to suggest how you should. But that's the easiest fix. If the Crown oversight is still controlled, you cannot do what I'm proposing. Essentially, what I'm trying to propose is give the Crown and the complainant the ability to consent to admission. And only if both of them consent can you move forward without a hearing. Now, I think that's a wonderful idea. I think there are situations where the complainant, represented by counsel, has no objection to some aspects of the material that's being adduced. If the Crown and the complainant and the accused agree, why do you need to go through judicial oversight? It seems like a very problematic idea, and I'm going to say, by the way, that you can never oust judges from anything because they won't let you. My system also retains oversight, but it removes the need for an application. So how do you do that? Not that difficult. Legislation is very important. So first of all, I want to point out that this is an invention from the Supreme Court of Canada. To start with, the idea that the Crown is covered by the procedure is invented by Justice Moldaver in the Barton case. It literally says nothing about the idea that the Crown is covered by this. So the courts have to retain this supervisory jurisdiction. This was a Crown invention, not a Crown invention, a court invention that was based on, we're going to have CBOYA as a common law regime for the Crown. Like, I'm going to tell you, even at the time, I didn't agree with it. I don't know who defendant's counsel might have been, but it sure was some smart fellow who said, no, this is a ridiculous idea. We can't do it this way. And I was actually thinking from a policy standpoint, it's a really bad idea. And the section doesn't say it should be done. The section says the opposite. Several Crowns fought hard for this. To their credit, the Crown and respondent in Barton was the Alberta Crown. They didn't ask for this specifically. They wanted control, but not like this. But the Attorney General of Ontario said, nope, you got to do it. It's got to focus. You got to go to court to get a ruling. The Attorney General of Canada, of all people, no, you can fill the gap, interpret it as applying to the Crown. This is a terrible idea. It's terrible because it has, again, combined with the other part of Barton that says the trial judge must have oversight. You can't consent. Even in the most obvious cases, we've got to go through the hurdle of 2 stages of proceedings so that everybody can dot the I's and cross the T's. These things can be fixed. And Kinnemore, they've jumped in even farther because Barton was like, well, a sort of clarification. No, Kinnemore now says we've all got to get together and have more and more applications. You can't do this. All of this feeds the beast. We don't want to feed the beast. That's not a good thing. We do not want to feed the beast. The beast is absolutely voracious. But we can fix this. It's not actually that complicated, right? It eats everybody. It doesn't care. So how do you do it? Well, I'm going to actually give you legislation. Now, keep in mind, I'm not a legislative drafter, okay? But this is what I propose doing. It has to be win-win. Everybody has to win. And to do that, you can't oust judges. Next, the objective is to separate the applications that are really contested from the ones where there's sort of some agreement that some of the material has to come in. So my proposal does that. Here's what I suggest. I've created a new section, 278.98, where the Crown and complainant, after consultation, I keep the complainant in the equation. And if you want to put a specific direction that says the complainant has the right to counsel, It is not necessary to prepare any application as long as the requirements of this section are complied with. Next, the Crown, if wants to admit evidence, has to give the defense notice 120 days before trial, because that will give the parties the time to figure out whether the defense has to make an application or not. I will say that the Crown must delineate the scope, and where admitted, under that scope, the defense can adduce or cross-examine on the same subject matter without a ruling. By the way, that's what used to happen anyway. Obviously, if the Crown tenders evidence, the accused has to be able to cross-examine. I've just included this clause because I think it's essential to fit with Section 276 and to reduce any scope of doubt. Fourth, if the defense wishes to adduce closely related evidence that's not the same, the defense doesn't get a free ride. They have to seek admissibility under Section 278.93, the ordinary way, or through my new section that I'm about to create. Fifth, in the case of an application, you're going to see that the defense has 120 days also. I can shorten it because obviously they're only getting the material from the Crown 120 days before trial. Finally, the Crown must notify the judge. And what's the purpose of doing that? Because the judge cannot put a hearing on. If the case of an application like this takes place, you notify the judge that the evidence is being admitted under 278.98, and you can advise them that the complainant has consented, and as a result, nothing in this section affects ultimate admissibility. What I mean by that is, all this does is rid the need for a scrutinized, vetted application. If the Crown and the complainant agree, who cares? The defense can object to the evidence under normal principles of admissibility, and the judge can decide that, the cross-examination on this point is going too far. Nothing changes that. It just gets rid of a hearing that we don't need. That's the Crown section. What is the defense section? Except in accordance with this section, and this section is called the simplified procedure. In the simplified procedure, the defense can attempt to go through this procedure instead of 276 and 278.92. They have to provide notice. They have to file a form which will be prescribed that will have basics of what we'd like to know about the evidence, what the evidence is and how it seeks to use that evidence. That's a bit simplistic, but you could obviously flesh that out a little bit. 4, no affidavit evidence anymore. It's ridiculous, and cross-examine on the affidavit's equally ridiculous. No way. You provide the simplified procedure. If the Crown goes for it after seeing what the evidence is and the complainant consents to, you're done. There's no need for anything. I think that's just better for all concerned. Upon receipt, the Crown has to consult. So I've kept the complainant in the equation. That seems important to most people. So I've kept it there. But they have to decide whether they will jointly consent to admission. Once the decision is reached, the Crown must immediately notify that it consents or requires the accused to go through the ordinary process. My hope is that the Crown will make judicious use of this, because I believe, to be honest, that this is an exercise of discretion. And if the Crown just says, we're not even considering this, I don't think they'd do that within the lines of the statute. But if it's in bad faith, you can get that discretion theoretically reviewed. I don't want any more of these nonsensical things. I'd like to hope this would work. And immediately notify that it consents to admissibility. And when this happens, the trial judge cannot order a hearing. It's banned. Of course, as per usual, the judge does not give up power over use and admissibility. You can control that at trial, but no more hearings, no more vettings where the simplified procedure is put into place. Why is this a win-win? I told you already that we have to reduce the inputs into the system if we're ever going to solve the delay crisis. And it seems to me that if we separate the easy ones, why have to go through and battle on every front? There are cases where communications or sexual activity are very clearly relevant to a particular proceeding, but we have to do applications anyway. There's a lot of them. We don't need them in the system. We certainly don't need judges to provide mandatory written reasons. It's all, we've got to separate stuff out of the equation. But the result of all this is that everybody wins. I think it's a winning proposal that will help reduce some of the mess we have in a way that protects the interests of all concerned. It can be modified or shopped or scoped in any way we need to get at the point, which is to reduce the number of applications within the judicial system. I like it for the defense. It reduces delay by removing unnecessary pretrial applications, reduces cost, reduces an affidavit. For the complainant, it keeps them involved in the decision-making process, and it doesn't have all this delay and in-courtroom multiple fights about sensitive information. If you don't need to do it, let's just move it, do it within the trial proper, and that's the end of that. It's better for the Crown as well. It encourages the simplified procedure, and it gets rid of the idea that we're better off to wait till trial or seek a motion for directions to determine if this information fits in, etc. It eliminates unnecessary Crown applications, and frankly, I think it reduces workload, cost, and delay. It's great for defense lawyers. No more paperwork, no more affidavits on behalf of their client. It's a very simplified procedure that will allow them to set out the evidence and what they have to do. Defense lawyers don't like this provision, but that battle's been lost already. So I think it's time to recognize we have to give to get, and this is one way to do that. It's great for judges, less court time, less doom scrolling through text. That's an actual quote, of course, from the famous Larson case in Saskatchewan. You get to keep control. If things go awry, you're still the boss. You still get to limit and control. And of course, this would be like any joint submission. Like if the parties agree, like the judges should stay out of it, quite frankly. That's the way the law has always worked in every single other area. There is, in fairness, one loser. There's always one loser in this proposal. The beast. The beast doesn't get fed as often. I've said it before and I'll say it again that we have an opportunity here. There is widespread public dissatisfaction with the criminal justice system and its treatment of sexual assault. We have a chance to do something about it. We should not waste this chance. Solutions remain possible. Thanks so much for listening and have a great day.